Iowa Court of Appeals. We have two cases for oral submission in this 10 o'clock session. The first of those cases is 24-1108, State versus Walker. We have Kent Simmons for the appellant, and we have Joe Ferrentino for the state of Iowa. So whenever you're ready, Mr. Simmons.
May it please the court. Good morning. I want to address the jury selection issue, of course, first, but I hope we have some time to get to the imperfect self-defense also, because I think it's a very important issue. Of course, the issue on the motions to excuse for cause is governed by State versus Jonas, our Supreme Court's 2017 case, but its predecessors go back over 100 years. And it's kind of interesting the way the Iowa Supreme Court has periodically needed to remind trial judges that close calls on excuse for cause should be called in favor of the defendant. The benefit of the doubt on those rulings should go to the defendant. And I'd like to read a short passage from Jonas to begin with here this morning. Quote, "We have long cautioned trial courts against allowing close issues to creep into the record and threaten the validity of a criminal trial. In State versus Teal, we stated," and now quoting Teal, "we see no occasion in the ordinary administration of the criminal law in this state for the close rulings on the qualifications of jurors that are constantly brought to our attention." Now, that Teal case was from 1912, and the court has had to keep reminding trial judges throughout over 100 years, kind of periodically. There was State v. Teal in 1912, State v. Beckwith in 1951, Williams in 1979, Neuendorf in 1993, and then we had Jonas in 2017.
From those kind of cautionary statements, are you advocating for a different standard of review here, kind of a lessened abuse of discretion review?
Yeah, I think you could call it a standard of review. I had kind of been debating that myself, and I kind of view it as a rule of procedure that was created by the court, that when we do have these close calls, that the judge must give the benefit of the doubt to the defendant. And that's just important to maintaining the integrity of the fairness of the jury system. And the court has said that in the case law. And actually, I would like to read just another short passage from the same long quote of the Jonas court regarding that application of the benefit of the doubt for the defendant. Quote, "Although a ruling may be technically right, it must be so doubtful as to raise a fair, if it must be doubtful as to raise a fair question as to its correctness, it is far better to give the accused the benefit of the doubt, to that end that he and all other men may be satisfied that his rights have not been invaded."
Can I ask you about the juror RL, your issue on that juror, and what the exact legal foundation for challenging? Would that be under 218.50? The circumstances indicate the juror was biased?
Well, correct. And bias is...
Overlap between the motion in limine and the strike for cause.
Right. And so the bias is kind of interpreted in a broad sense there when he says bias. And this, you know, both of these jurors were very forthcoming and honest about their thought processes on these questions. And for the second juror, R.L., he was very forthright and firm that he could separate his knowledge about the guilty plea to felon in possession from the other issues on the charges that remained for trial, except that toward the end, he was directly asked if he could keep promise. I don't know if they used promise, but the question was to the effect, can you promise you would keep that knowledge of the plea to that charge out of your decision-making process? And to that, he said, and I think it's probably best to quote it, he said, he started to say he could be fair, but then he paused and said, it all depends on what's presented in front of me, you know. And he explained that it might come into his decision-making process depending on what was in front of him. So,
To me, like fitting under K, like his formed or expressed opinion. And I'm wondering if O is a little bit different and that it talks about the circumstances. So basically this juror knew, prospective juror, knew that the defendant was a felon, which none of the jurors were supposed to know as the evidence came in at trial. So I'm wondering, again, if that maybe fits under those circumstances more than what he expressed to the court?
well, yeah, I think it can be interpreted that way. I mean, on neither one of these issues is the subsections in the rule right on point with what the problem is. But I think that the legacy of Teal to Jonas is that the question is, do we have a problem with whether this juror can be fair and impartial? And I think that's more of a common law rule of procedure again. I think there's not a problem, even if they don't fit right into the rule of procedure. And I think both of these jurors are basically telling the court, I'll try to be fair and impartial. Now, the second one.
Really know that from the transcript, though? I mean, isn't that the inherent problem with these challenges, that a trial judge sitting there with the jurors in front of them will hear and see things differently than it comes across in the transcript? You know, the phrase, I would hope so, you could say that differently and it might mean different things. So shouldn't we defer to the court in these judgment calls?
Yeah, and I mean, the first step you have to take when you're reviewing this is to look at everything the juror said, of course. But in the first case, in the first juror's case with J.W., she was very firm, I think, because she said she would think so, she would hope so, that she could be fair and impartial and learned whatever and exclude whatever she learned in the media out of her decision-making. But then she said, I can't promise you I can do that. And she said, that would be a lie for me to promise you that I can keep that out of my decision-making process, the extrajudicial information. So I think that was very firm, and it certainly gets it to a close question, which I think the case law says close questions have to be resolved in favor of the defendant in order to protect the integrity of the jury selection system. I think we've covered a lot of everything we need to cover on that issue. I would like to take just a minute on the imperfect self-defense.
I know you asked the Supreme Court to retain the case. So is it within the power or authority of our court to adopt that imperfect self-defense? I know we have unpublished cases where we said it's not the law, but...
Well, I think it is. And I think, you know, often the case you're restrained by the fact that there's prior Supreme Court precedent, and you certainly can't overturn that. Or there might be, you know, other reasons that it would be best for the Supreme Court to do it. But in this case, you know, it's never really been resolved by the Supreme Court. It's hard to see in the case law whether they've had many opportunities to do it. But
I know in one of our unpublished cases, we mentioned an earlier case, further review had been sought, and they didn't take it. So if they thought we were wrong, would those cases not have been an opportunity for the Supreme Court to speak on it?
I don't think those, and I'm sorry, I can't specifically remember those right now, but I don't think they were argued the same way as we're arguing this. And I see I'm past my time.
If you want to just, you'll have more time on rebuttal if you want a moment to conclude.
I just want to conclude that it may be difficult at first blush to think that there's a factual basis for the imperfect self-defense. But, and I can go into this more in rebuttal if you'd like to, but, you know, the problems for justification were that Mr. Walker did strike the other person first in the face, and that he did pick up a gun that was on the floor. Those are tough facts in justification cases. But there was also independent testimony from a man who described himself as the biggest bouncer working that night in the bar, 300-pound bouncer, had Cameron Barnes in a bear hug, and he was pulling him away and trying to get him outside. And then just before the shooting, Barnes broke loose, and the bouncer testified Barnes was going back to get into the fight again. So going, and with the tape and everything else, going toward Mr. Walker. So there was that new threat after the initial altercation was over with. And also,
Thank you. And you can continue that thought on rebuttal if you like. Thank you. Mr. Ferrentino?
May it please the court, counsel. I'd like to begin by discussing the jurors as well. And I have two main points of emphasis, but Judge Bading, you already hit on one of them, which is that this is a credibility determination about these two jurors. And in situations like those, we ordinarily defer to the district court because of its ability to observe the witness or observe the juror in this case.
Though a credibility determination, if we're talking about subsection O and kind of what I was asking your opponent, because it talks about circumstances rather than what the juror has formed or expressed. So, I mean, it's black and white that he knew that the defendant was a felon, and none of the jurors were supposed to know the defendant was a felon. So, like, if that juror had been seated and had found out, it would have been grounds for a mistrial, probably. So is there any deference on that? It's just a fact question, right? Like, what do we make of a prospective juror knowing that the defendant's a felon?
Well, I have two responses to that. One is that I wish the record were a little bit better because you may read the questioning differently, but the way that I read the questions to that juror, the questions are focused on what I would call the crime at issue here and not so much the status of being a felon. And then the argument made to the judge once that juror is gone is about him knowing the defendant's status as a felon. And so I wish we had a little bit more about not just what do you think about this crime, which is what it seems to me the questioning is about, but what do you think about that status? But I also don't think it's really a problem here because RL was very forthright, as Mr. Simmons said, that you can be guilty of one thing and not be guilty of another. And I believe someone who has that attitude is also going to believe you can be guilty of two things but not guilty of a third. And so going to the circumstances, I think the district court was able to observe that, determine whether that's a credible belief of RL's, and decide that this juror is not going to be a problem because they have sort of a laissez-faire attitude about prior bad acts or prior crimes. So I'm not concerned with RL sitting on this jury because even if he knew about this status as a felon, it doesn't seem like, I think he says I'm indifferent one way or the other. It doesn't seem to me that he's going to be bothered by that, and that doesn't produce these circumstances of subsection O. The other point of emphasis I wanted to get to is that when we're comparing this case to cases like Neuendorf or Jonas, and we're talking about rehabilitating jurors, I've been thinking of it as a rehabilitation journey. If you have an ACL tear, you're going to need more rehab than if you just rolled your ankle. And Neuendorf and Jonas, we have jurors expressing what I think are much more serious issues than here, where RL is saying, you know, it doesn't bother me about this crime or the status as a felon, and the other juror is saying she doesn't even know what she remembers. She's just worried about something coming back up. Neither of those is as problematic as the views expressed by the jurors in Neuendorf and Jonas. So I'm not even sure we're talking about rehabilitating these jurors in this case. We're talking, you know, they have not expressed previous points of view that they then need to disavow, which is the language from Neuendorf, that they wanted the juror to disavow those prior views.
That Jonas applies since the preemptory strikes were requested, that it's sort of all or nothing here, that
I agree. Jonas lays out those 4 steps, and I think 2, 3, and 4 are basically uncontested, but we're fighting about 1. My holdup is on 1, that I don't think the district court was incorrect in declining to strike these jurors for cause.
Would you agree with the defendant that the judge's suggestion that, you know, you haven't asked like the magic question, do you think that approached rehabilitation or was rehabilitation?
Approach rehabilitation. I think the district court was being very careful. I don't view this as a particularly close case the way that Mr. Simmons does, but if there's any rehabilitation to be done, that's the effect of it. And then, you know, I'm not worried about her response. If she were gonna pick up a cue and try and get on this jury despite her whatever views, her biased views that she's alleged to have, I think she would say something more strong than just "I would hope so." I think she says "I would think so" again. I sort of think that's the way she talks. But again, we can disagree about that. That's why we look to what the district court, how the district court viewed their responses. Let's see.
we move on to the imperfect self-defense, could I ask you one more question about that subsection O? And Mr. Simmons talked about bias being kind of like a broad concept, maybe not, like you mentioned Jonas and Neuendorf, like maybe it was just as bad because knowing someone's a felon is kind of something that's going to be like implanted in the brains of the jurors. So do you agree that that concept of bias is fairly broad in that rule?
Yeah, I think I can agree that bias is a fairly broad concept. I just don't know that we have any sense that this particular juror is biased. And that's why I think the sort of motion in limine analogy is instructive, because when we have a preliminary ruling on a motion in limine, that can be overruled, for lack of a better word, by the same judge later if more specific information comes to light that makes them think that they were wrong on this particular point. So if a motion in limine is a generalized ruling, here we have an opportunity to, in camera, interview this juror, and he expresses, to my view, no bias, even knowing what he knows about this defendant, then I don't think we have a situation that rises to those circumstances. I just think he's defeated that.
Counsel, do you draw any distinction between a motion in limine prohibiting the jury from finding out that the defendant was a felon? Because I think implicit in that is once you impanel a jury and we get going, there's no stopping and let's say the cat's out of the bag and it comes out in a testimony from law enforcement that he's a felon. You can't start voir direing the jurors and be like, what'd you think of that when it happened, right? Whereas now we have a snapshot before the trial occurred where we have that knowledge and you're able to actually question. I think that's what Judge McKeever was getting at was, yeah, that might have been my in limine ruling, but now we have an opportunity to actually question the juror about what they think of that issue. Do you think that distinction matters in terms of how we look at the case?
I guess I do think it matters. I think that's, essentially the point is we're trying to get going on, I don't think we would voir dire the entire jury mid-trial, both because it's time consuming and we've already got this trial going and we want to keep going. But at this moment, before we've sort of put the train on the tracks, so to speak, we have an opportunity to ask this one individual. It's not going to use a lot of time. It's not going to expend a lot of resources. And we are able to determine what they think of this rather than sort of like, there might be sort of a group think kind of going on once the jury is impaneled, but when there's just one person involved, I think we can get to the heart of it with his personal views.
Counsel, in the short time that you have left, let's talk about the imperfect self-defense theory, and specifically your error preservation argument. Can you explain that to me a bit more? Because it seems sort of hyper-technical. Because if the court had granted the defendant's request to give that instruction, technically the court would have been adapting that theory, right?
I think so. I can imagine a situation, and I'm not suggesting that this is the situation, but you can imagine a situation where, maybe an element has been left off that we all know should exist in the jury instructions, and so someone urges the adoption of that element knowing that it's a correct statement of the law, but they may think it's not so beneficial for their side, or they may not personally think it's the correct way the law should be, sort of normatively, but they might still urge it, and it's not asking the court to make that the law, or it should be the law. And I do think it's a little bit different. If you want to accuse me of being hyper-technical, I think maybe that's right. But I do think there is a distinction to be drawn between saying this is the law and this should be the law. But more importantly, it's not the law. And we do have these 4 unpublished cases, all of somewhat recent vintage, saying it's not the law. I don't feel like unpublished is doing a ton of work there. If there were one stray unpublished case, maybe you could say, well, that's just an unpublished case. But when you have 4 that are pretty close together in time and pretty recent, all saying the same thing, the legislature, I see no reason to think that the legislator is not aware of those simply because they're unpublished. It seems to me that this has become sort of de facto precedent, if not exactly de jure precedent. And no one has changed those. There hasn't been further review taken. It is not the law.
Do you agree, though, that we would have authority to go a different direction if we wanted to?
Yes, I would agree with that. But I would ask you to affirm nonetheless. Thank you.
Simmons, rebuttal.
Thank you. I want to address Judge Sandy's question first. It is a very strange procedure when you can voir dire a juror on a motion in limine result. Of course, they didn't tell him there was a motion in limine, but and I think that the voir dire they did with him on that point was kind of incomplete in one way, because if you think about Rule 403, it's just that you have to prove in the motion, you have to prove by a preponderance of the evidence that there's a danger of unfair prejudice. And at first he was so firm that you could say, yeah, he presented that there would be no danger of unfair prejudice because he would keep it out of his decision on the remaining 2 counts. But then at the end, he kind of reconsidered on that, which opened up that danger of unfair prejudice. He said, well, actually, I don't know. I might use it. It would depend on what was presented to me in the evidence. So I think that was kind of, I hate to use the word imperfect, but an imperfect voir dire on that question, because that danger of unfair prejudice, a juror just can't really predict. And he was fair to say he could not keep it out of his mind that he was a convicted felon when he's coming down to making a decision as a juror.
Juror, it's a little fuzzy to me. So they broke for the day, continued the next day with the same, let's say 26, 27 veneer up front. But, and so then this juror came back on the second day after they broke and said, hey, last night I read something. Correct. Is that what happened? But he was still one of the chosen, so to speak, that was in the grouping. Is that right?
Right. Well, He was yet to be examined when the second day came up, and it was either the night before or the morning of the second day when he came up. And he said a headline had popped up on his Google News application, I guess it was. And so all he knew was that he had pled guilty to being a felon in possession on Monday, on the first day of the trial.
To the attention of the court in chambers outside the presence of the other jurors, I assume?
Yes.
All right.
He brought that up, you know, it was kind of like raised a hand, he needed a in-camera. But the other thing then, on that, I think you need to focus on that juror when without being prompted.
Counsel, you have 2 minutes left, and I really have a question that I'd like to ask you about the imperfect self-defense. I apologize for interrupting you. Here's my struggle with the imperfect self-defense, if I could. It seems to be indicating that if a person subjectively believes deadly force is necessary, they truly do believe it, but it's subjective to that person. But objectively, it's unreasonable. Do we have any history in Iowa law that allows for culpability to be diminished based on that subjective belief, number one? And the second part of that question is, isn't that subjectivity, objectivity already encompassed in the self-defense instruction as it exists now?
No, I don't think it is, because the self-defense instruction as it is now is totally based on what a reasonable person would believe. This I kind of call it a lesser included defense than full justification, because it allows the jury to decide, did he truly believe this? I mean, even though we don't believe it was necessary to use that force, did he truly believe this? Was he truly in fear of serious injury or death? Did he truly believe it? And then...
Thing, counsel? Like, if he truly believed it, but they don't think that that's objectively reasonable, wouldn't that impart to his objective reality? I mean...
The point of the defense is that they're directed to find that he didn't have malice, is what it comes down to. And yes, you are correct. You can argue, look, there wasn't any malice here. He was a little off base, but he really thought he was in danger. There was no malice. I mean, you can argue that. But this is a jury instruction that directs the jury as to how to do this. And it's supported by law. And it's not explained explicitly or well enough by any other instructions. So the court has to give that instruction if it's good law, and it's not sufficiently covered by the other instructions. So I think that the imperfect self-defense, if you would like to create a precedent there, there is a lot of interesting research, and the only thing I kind of have going for me in the case law that relates to Iowa is that Eighth Circuit case from back in the late 70s. And in the late 70s, the federal courts had a lot more room to move to give defendants relief on their convictions. And one of the things that the Eighth Circuit said in Reinhart versus Brewer was, and this is one of several things they said that defense counsel should have done in the state trial. They said he could have and should have argued imperfect self-defense. And I'm not sure I think they cited one case from somewhere, but it wasn't from Iowa.
Time has expired. If you want to wrap up, that would be...
I would just like to wrap up with a couple things. First of all, on the first issue, it certainly appears that the state has conceded that this standard of review will be presumption of prejudice if you find abuse of discretion. I would also just like to make a personal request that you're free to ignore. If you do decide that the case can be reversed on one of the issues, I ask that you rule on both issues so that there's direction provided for the trial court on that. Or if the state should take further review, it's always nice to have a decision on all the issues. Thank you.
Thank you to both of you for your very helpful arguments and your good briefing in this case. State v. Walker will be submitted, and we will have a written decision as soon as we can. Thank you.